and we have the pleasure of
Sukuma hii mlango Chloe, niko class. Kwa wapi na bwana? Si class yani.
ni sawa Karo. All right, we don't want to waste any minutes. I want to introduce our guest speaker. Our guest speaker goes by the following profile. He's a commissioner of oaths, data protection consultant. I'm introducing him so that in future, if you want his services, you will be able to get in touch with him so that he assists you in all manner of things. So he's a commissioner of oaths. He's a data protection consultant. He's a certified secretary. He's also certified legal and compliance auditor, all right? So which means he can come to your organization and audit your data protection processes and procedures. He is also a member of the Law Society of Kenya. He's also a member of the Institute of Certified Secretaries of Kenya and Kenya Bankers Association Working Committee on Data Protection. So you can see he has a rich experience and knowledge about data protection. So tonight, we are going to listen to him. Kindly take notes so that you can be able to ask him questions at the end of the first segment. Keep your questions, then we'll ask them at the end of his presentation. Anthony, we do not want to waste any minute or second. Ladies and gentlemen, let us welcome Anthony Ng'ang'a so that he can be able to assist us in understanding data protection and its essence in organizations. Karibu, Council.
Good afternoon, and thank you very much, Richard. Please confirm that you can hear me very well.
Very, very well.
Yes, you can.
Yeah, very clear.
Many thanks for that.
Very well.
All right. Thank you. Thank you for that confirmation. And I want to begin by confirming my pleasure and honor to be with you today as we discuss data protection and privacy. In my experience as a governance and risk and compliance professional, new laws and regulations will often pose serious, serious challenges for organizations as institutions, start to put in structures and processes to govern or to enforce certain regulations. Sometimes organizations and individuals will struggle with gaining foot and getting a hang of things. So that being said, and without much ado, I would commence with the presentation. I want to make it as simple as possible and as interactive as possible. Richard will and the team will support with collating the questions and responding to your questions. I know it's after 5 and many of us are coming from work or from other engagements. So we will try as much as possible to be straight to the point and address the issues that are at our disposal. To begin with, there's usually data protection. The regulation that we have in Kenya, just to give a context, is largely borrowed from what we have in the European Union, which is the GDPR, that's the General Data Protection Regulations. And the reason why we have these regulations, and we are seeing other regulations in Eastern Africa. Recently, Tanzania passed a similar legislation. Rwanda also has a similar legislation, and Uganda is steps ahead in terms of data protection and privacy. That is a legislation that they had even before Kenya. So the reason why we are seeing all this global movement is because data is we are living in the data age, you know, as previous civilizations are defined by certain elements like industrialization, agrarian revolution, and all that. The current gold mine is data. And I know we have had discussions about GPT and many other innovative interventions around data. It therefore becomes imperative for countries like Kenya to have this legislation that seeks to protect and preserve personal data. Actually, the law does not prohibit collection and processing of personal data. The law only requires certain safeguards to be put in place by individuals and organizations that are collecting personal data from the public or from natural persons within the republic. I think having given that context, we can move to the next slide. And at this point, I would request my colleague, I would request Hosea to share his screen and to play this video. Or let me see if it can play from my end.
आज खुशनुमा हो गया। हिमालय में बार-बार क्यों आते हैं एलियन? हिमालय का हिमालयन देखिए रात 8 बजे।
Its liver is all nice and good to eat. It's kind of good, really, just to be skewered.
Sasa, can I talk to you later?
Anthony, the video stopped. There seems to be no sound.
आज खुशनुमा हो गया। हिमालय में बार-बार क्यों आते हैं एलियन? हिमालय का हिमालयन देखिए रात 8 बजे।
Its liver is all nice and good to eat. It's kind of good, really, just to be skewered.
हाँ
हेलो, हाँ क्या कर रहे हो?
टीवी देख रहा हूँ।
दाल चावल रखे हैं, गरम करके खा लेना।
हाँ ठीक है।
बाहर से कुछ मत मंगाना, सुन रहे हो ना? तुम्हारी आदत पता है मुझे।
अरे तो आकर देख ही क्यों नहीं लेती कि क्या खा रहा हूँ?
तुम ना ऐसे ही हो।
बाय।
evening, sir. Thank you for calling Hot and Fast Pizzas. Can I
I
have
want to order a pizza.
Surely, sir. Can I have your multipurpose identification number?
One sec. Yeah, it's RSP 06031983MI.
Thank you for the number, sir. Am I speaking with Mr. Rajneesh Haspuri from Baikala, Mumbai?
Yes.
The number from which you're calling is 9191930484 and your residential number is 22223244.
Yes. But how do you know all this?
We are connected to the system, sir. We have all the related information.
Good. I want to order a regular size seafood pizza.
Sure, sir. But that's not a good idea.
What do you mean?
As per your last medical records at Bombay Hospital, dated 9th August 2015, you have high blood pressure and a high cholesterol level, sir.
What are you saying?
As I said, we are connected to the system, sir.
Oh shit. Okay. Then what would you recommend?
Try a low-fat super veggie delight Mexican pizza. You will like it.
And how can you say that?
As you borrowed a book titled Popular Mexican Food from National Library last month, which is overdue to be returned, sir.
Okay, I give up. See, I'm very hungry. Send me one of those. How much would it cost?
The total cost is rupees 365, including taxes, sir.
Okay, fine. You send the pizza. I'll pay for it by my credit card, okay?
I'm afraid you have to pay us by cash, sir. Your only active credit card of Apex Bank is over the limit, and amount due is rupees 79,765 since July 2015. That's not including the late payment charges on your last cash withdrawal.
That's fine. You send the pizza. Good evening, sir. I guess I will have to go to the ATM in the next lane.
Sorry to inform, but you can't, sir. You have reached your daily cash limits, which was withdrawn at an ATM at Domestic Airport Terminal B when your wife took a flight to New Delhi today.
Damn it. How do you know?
As I said, we are connected.
Yes, you're connected to the system. Just 25 minutes. You send the pizza. I'll pay by cash. How long would it take?
25 minutes, sir. But if you can't wait, as you said earlier, that you're very hungry, you can always come to a nearest outlet.
What?
As you're just 4 minutes away from a nearest outlet in your area, and you have a car of number MS01XE3484, Yakazi brand.
Oh, God. How the hell you
As
know?
I said to you earlier, we are connected to the system, sir.
What the? I just want my pizza.
Okay, your order is confirmed, sir. Anything else, sir?
Nothing. Would I be getting that 3 bottles of cola mentioned in your menu?
We normally would, sir. But based on your medical records, you're also a diabetic and...
Enough! Send the cola along, you bitch!
I request you, please do not use such language, sir. You were convicted on 13th March 2015 for using abusive language to a policeman.
What?
And you were also arrested for misbehaving with a lady in a party.
Shut up! Just shut up, you bitch!
Thank you very much. I believe we still are together.
Yes, we are.
All right, thanks. So we are done with that segment of the video, and I'm sure we were able to pick a few items. Just to mention but a few, All right. Please confirm that you can now see my screen.
Yes, yes, we can.
Yes, we can.
All right.
Yes, we can.
Now, having seen the video, and also I am sure that I'm certain that we have some bit of information about the topic of the day. Now, the biggest question in the house is who has been trawling through my personal information? We could probably give 2 or 3 people a chance to comment in less than a minute. What were the data protection issues that we picked in that conversation? Richard, would you be able to run through that quickly? All right. Am I audible?
Yes, you are. We can put our responses to the chat box, or somebody can unmute themselves and say something.
Yeah, just to hear what we picked. What do we think was off in that conversation in the video? Yes, Rogers? Rogers, you may unmute yourself and comment.
It looks like it was a mistake. He has lowered his hand.
Oh, okay. So do we then ask members to type in their observations in the chat option? Eh?
Yes, that is even better. Jen, I can see you are on the chat. You can say something.
Richard, you've pointed me out. No problem.
Yeah,
so the issue I noticed is the lady had too much information about the gentleman. Like she had the police record. She knew how far the gentleman lived, so he could come and pick up the food. She just had too much information that the guy had not given to her.
Thank you. Somebody else? Joyce, you can say something. Mwanzi Luseka, you can say something.
Yeah, I think what was off is how the lady had too much information and the guy was feeling really uncomfortable, and she kept saying that you are in the system, and he kept wondering, like, how am I in the system? Probably he had not subscribed to anything like that. Yeah, I think that was the issue.
Thank you very much. Joyce?
I would say the gentleman got annoyed to some extent, and he felt that his privacy was being like invaded or something.
Very good. Moses, you can say something.
In my opinion, I feel like although we are heading towards we are in the data age, the tech age, and systems are being sort of like merged. This individual was not aware and didn't look like he had consented to that much information about himself being out there. And it was so much with this woman that it was even a security risk to the gentleman himself, because if they know exactly even where they stay in the car they just bought, then it becomes a security risk to the individual.
All right, Brenda. All right, it's Brenda who was talking. Brenda, you have something to tell us?
We have some chat. We have some have commented on the chat. Moses, you say there is a serious data breach on the gentleman's private data. No consent had been given by him. Rogers, financial record, health records were paraded in public, which should be private, including location, which is a security risk.
Good.
All right.
I think that is enough.
Yeah. All right. Thank you very much, members, for the items that you have identified. And actually, that will be one of our major reference points throughout the discussions for the day. Now, we start with our training objectives. We hope that what we have resonates with your personal objectives for this training. And the first objective is to be able to understand the global perspective of data protection and privacy concepts, as I mentioned earlier. The second one is for us to be able to examine the legal and institutional framework for data protection and privacy in Kenya. The third is for us to be able to examine the rights, responsibilities, and obligations for both individuals and organizations. Fourth is to enable us understand pertinent provisions of the Data Protection Act and their applications in our day-to-day lives, both in the office and even at our personal lives. The other objective, number 5, is for us to be able to understand key obligations under the Data Protection Act. Number 6 is we need to also understand and look at fines, penalties, and other expenses for non-compliance. That is simply repercussions for non-compliance. And we also need to see what is my recourse as an individual in case my personal data is in case I suffer data breach. Perfect. Please allow us to start with a few definitions. Of course, there are many definitions under the Act, but then we are looking at a few of them. And the starting point, and even before we look at the definitions, please allow me to mention that this Act is centered around a natural person. It is centered and it is even leaning towards protecting a person's, privacy and personal data. And this person, a person like you and I, or the person whose data is being collected and or processed, is called a data subject. That is you and I, a natural person who is giving out data. Another key point that we need to define, another key term that we need to define is what is personal data. Please note that this word is very broad and it is defined in, its definition is limitless because it talks about any information relating to an identified, like an identified person or a person who can be identified. For example, if there is some information about you that whether you are identified or not, that becomes personal data, as long as even if you are not identified, you are identifiable. What do we mean with this? We mean that in case my full name is given out somewhere, although they don't have details about my identity, who actually this person is, where do they live, what is their ID number, what is their, what do they do and all that. Provided this name belongs to a person who is identifiable, then it becomes personal data. Now, and the safeguards that we have for personal data is a bit lower than the safeguards that we have for sensitive personal data. Again, sensitive personal data is information that is information that is offered more protection in the Act, and this is information about your pertinent details, what we would say personal detail, very personal details. This includes race, health status, also includes ethnic or social origin, includes conscience, includes belief, genetic data, biometric data, property details, marital status, family details, including the names of the person's children, spouses and parent, spouse or spouses and parent, a person's sex, or even a person's sexual orientation. The next concept that we would need to define is what is meant by personal data breach. And in simple language, data breach means an interference into the security of your data that leads to either accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data. What this means, like what we saw in the video, is a clear example of a personal data breach. Now, for the lady to be having all that information about the caller, there must have been a data breach in that the company was allowed unlawful and unauthorized access to the customer's data. That is the connection between all the sensitive data and the disclosure of this data to the hotel. That's what is meant by personal data breach. And without even taking it very, very far, assuming you, Richard, allow me to keep using you every now and then as an example, but of course I will use other students as well. If Richard today runs a kiosk somewhere, or an agent, say a mobile money agent for any of the telcos of the mobile money service providers, operators that we have, and somebody visits your office, your shop, makes a withdrawal or a deposit or some sort of a transaction, then you will have access to their name, phone number, and also their ID. If by any chance this information is used for any other purpose other than that transaction, that becomes a data breach. If you disclose this information to any other person, any third party, outside the provisions or outside the purpose for which this data was obtained, then that becomes a data breach. And those are just some few examples. The other concept that I would like us to define is a data controller, and differentiate this from a data processor. So a data controller is a person or an entity who determines the purpose and means of processing personal data. And we will look into this slowly. So what this means is that if say I am an industry, or I do manufacturing business, my name is Anthony, then I have a friend called Moses, for example, or a business partner who is Moses, and I need some data for me to be able to know what what kind of products or what kind of improvement should I put in place to ensure that I retain or I gain or retain a competitive market edge. So if today I give instructions to Moses to go into the market and to undertake a research, that is to obtain certain information or certain data for my company to use in improving my manufacturing business, then because I determine the purpose and means of processing this data, and even how this data is to be collected, and even what kind of data will Moses be required to obtain from the public, then I am a data controller. Now, Moses, who is collecting this data for me, and he's also processing this data to produce a report that I will consume, because I may not need all the data that Moses collects, but he's going to process this data and convert it into, say, a report that will be consumed by myself as the manufacturer. Then he becomes a data processor. All right?
Yeah.
And in some instances, a data controller can also be a processor in some elements. And even the processor could be a controller in some other elements. For example, if I told Moses to collect 5 classes of data, but then Moses realizes I might need 5 other classes of data for my own personal use. Say this is something that I can do with this information. So I will be the data controller for the 5 items that I have instructed Moses, and he will be my data processor. If he decides to collect any additional data, from the customers, from the respondents in the research, then he is a controller to that extent. I believe that, and that would be the distinction that I would want to bring at that point. And finally, we have heard of the term consent very many times. Even the feedback that we received from the attendees, the word consent has been mentioned severally. I would like to bring to our attention that the term consent under the Data Protection Act is a very elaborate, there is a very elaborate provision. There are very elaborate provisions as to what conditions must be met in order for sufficient consent to be given by a customer. Please note these conditions, that the first condition is that the consent must be express. What does that mean? It means it must not be identified, it must not be implied. Implied consent would mean that it is being read from the circumstances surrounding, the whole question of whether there was consent or not. So number one, consent must be expressed. Number two, consent must be unequivocal. What unequivocal means is that this consent must be so direct and straight to the point that there are no two ways of interpreting it. It is either black or white. There's no in between. That's what we mean by unequivocal. The third condition is that it must be free. What this means is that there must be, there must not be any threats, any duress, any coercion, any form of external force that would have left the data subject with no other option than to give the consent. So it must be free. The fourth concept or the fourth condition is it must be very specific. For example, if I have given consent, if I'm accepting to give my telephone number to a company, say a marketing company, my consent must be very specific as to what this company is allowed to do. So ideally, the company should tell me, we are going to use your phone number for items 1, 2, 3, 4, 5. Then the customer is supposed to, indicate their consent for each of those use cases for their telephone number. And number 5 is that this consent must be informed. What do we mean by this? Is that when I am giving my consent, I must be able to understand and to comprehend what is it that I am giving my consent for. So it is upon data controllers and data processors to ensure that the consent that they receive from their data subjects meets this threshold. Because if consent is to be subjected, is to ever be questioned, then all these conditions must be met. And if any of them has not been met, there's a high likelihood that the consent that this company is holding onto could be declared as invalid or ineffective. So these are the main definitions that we will be defining today, and with your kind permission, we can proceed to the next slide, where we would like to look at the general overview. Again, as I said, the Data Protection Act and this regime does not exist in isolation. As you are aware, the Constitution of Kenya is the supreme law of the land, and even the Constitution itself has certain provisions that sorry about that, just a distraction. My apologies about that. So the supreme law of the land, which is the Constitution of Kenya, has various provisions that seek to protect the right to privacy and dignity of citizens. That can be seen under Article 28, Article 31, and even 35 on access to information. What this means is that even the act, the Data Protection Act, is enacted on the foundation of these particular provisions of the Constitution. That is Article 31 of the Constitution. So that is the primary or the foundation of data protection and privacy. Again, now from there, the next piece of legislation which consolidates all the protection on data on personal data is the Data Protection Act of 2019, which came into effect on 25th November 2019. And to give effect to this Data Protection Act, there had to be regulations, all right? And there are 3 different regulations that have been formulated under the Act. That is, number 1, the general regulations. Number 2, the complaint handling and enforcement procedures regulations. And number 3 is the registration of data controllers and data processors regulations. Again, these regulations flow from the Act, and they regulations seek to give effect to the substantive provisions of the Act of Parliament. Kindly allow me to mention also that in various sectors in the country, there are other statutes that that govern certain sectors with implications on data protection. If we could start with data protection, with the Banking Act, the prudential guidelines for the banking sector, other regulations like a particular prudential guideline could be on consumer protection. The CBK prudential guideline on consumer protection has provisions touching on data protection. Other acts would be the Health Act, would also be HIV and AIDS Act, which has particular provisions touching on data protection, particularly for that industry. The Employment Act also has certain provisions about that touch on data protection. So this being the legal framework, then we ask ourselves, of course, we already have the Office of the Data Commissioner, of the Data Protection Commissioner, which is the primary institution tasked with enforcing the Data Protection Act. At this level, we move to look at certain institutions or the institutional framework for data protection in Kenya. To begin with, every data controller, every data processor is required to have internal processes, procedures, and systems that are designed to ensure adequate protection of personal data within their custody. In this, as part of these processes, procedures, and systems, there are internal complaint and dispute handling mechanisms. We have started when we started with the institutions, we started with the data controller and the data processor as an institution. So there should be sufficient safeguards. In the event that as a data subject, I am not satisfied with how the data controller or processor dealt with my data or how they handled my complaint, then I can now lodge a complaint to the Office of the Data Protection Commissioner. In the event that I am not happy with how the Data Protection Commissioner handled my matter, then I have another option of approaching the courts of law as a matter of appeal from the decision of the Data Protection Commissioner. So, are we together up to that level?
We are progressing very well. Thank you.
All right. Thank you very much, Richard, for that confirmation. All right. So we proceed. Again, as we said, the next level, we ask ourselves about the key principles of data protection. And these are provided for under Section 25, which, again, this is the test. In case somebody had a complaint against, Anthony as a company, and this went all the way to either the data commissioner or to the court of law, these are the principles that will be, that this particular, that Anthony as a company will be subjected to. they should guide us as data controllers and processors on how we handle personal data. So the first principle is that when you are dealing with personal data, you must ensure that there is fairness and transparency in not only processing but also collecting. What do we mean by ensuring that we are fair and transparent? For fairness, we are required to only obtain, or we are required not to use our superior position to the disadvantage of the data subject. For example, say you are an employer, you have a desperate job seeker who is really desperate about a job, or you are a HR professional, or you are a recruitment company. There's a job seeker somewhere who might be very desperate and in an inferior position. So what you are required to do as a data when you are in such a situation, then is to be fair and to only collect the data that is necessary. And you are also required not to abuse your superior position. For transparency, you are required to inform the data subject that I am receiving your data, your personal data, for reasons 1, 2, 3, 4. If as you would probably for any other reason other than the stated reasons, then you are required to inform the data subject so that the data subject either gives a nod or says no. So the other principle is that collection and processing of personal data must be for, number one, specified and legitimate purpose. All right? And when you have been given this data, you are required not to use that data for any other reason beyond the specified and legitimate purpose. Specified is something that we are able to gather, but to add some weight on legitimacy is that the purpose must be lawful. That's what legitimate stands for. So you are not allowed to collect my data for unlawful purpose. The third principle is purpose limitation for data collected. Simply means if you collect my personal data for purposes of recruitment, then you are not supposed to use that data as you are not allowed to use that data for any other reason other than the recruitment, the purpose that you collected the data from me, unless if you have specific consent for me for further processing of this data. The next principle is that collection of personal data relating to family or private affairs to only be collected where there is a valid explanation and also when necessary. When you're giving details about yourself, about your family and your private affairs, there needs to be a valid explanation. Please note that the Act is very, very deliberate on the language that it chooses. For example, a valid explanation places a higher threshold, and it means that an explanation alone is not sufficient. It must be a valid explanation. Please remember, as we said, we are protected constitutionally from having information about our private affairs being disclosed unnecessarily. That is a constitutional requirement, and it has been restated in the Act. Now, as a data controller and a data processor, you have an obligation to ensure that the data that you hold, the personal data that you hold is accuracy of the data that you collect. Now, remember again, data subjects have a constitutional right, leave alone this protection under the Data Protection Act. They have a constitutional right to have any inaccurate data about them rectified. I believe that by now we are able to see how the interplay between the Constitution and the Data Protection Act. Everything is flowing from the Constitution, as we mentioned earlier on. So, again, there are timelines within which data is to be maintained. In some areas, 7 years, in some other areas, 5 years. Remember, there is now a restriction for data controllers and data processors that you should not continue holding data beyond the necessary timelines, or even beyond the timelines placed by the law, by statute or by the law. All right? So the other principle is in relation to transfer of data outside Kenya. Recently, the Data Commissioner published guidelines on cross-border transfer of data or information. I think that should be a week ago. And generally, there's a restriction against transfer of data outside Kenya, unless if the data controller or processor is able to provide proof that there are adequate data protection safeguards in the country of where this data is being transferred to. That's number one. And number two, that there is customer from data subjects. These two conditions must be met before this data is transferred outside Kenya. And of course, the recently published guidelines provide more insights on how this is to be effected. You know, how protection on or the restriction on cross-border transfer of data. Now, the next question that we are going to look, that is item number 6 of our presentation. What are the key obligations that we have, that this act, puts in place? Remember that most obligations lie with a data controller and a data subject. Sorry, data controller and the data processor. That's where most of the obligations lie. The first obligation is the obligation to register, and we'll be looking at the registration process in the upcoming slides. And of course, the law provides that no person is allowed to collect or process data, to collect or process personal data without registration. But there's a threshold for registration. There are companies that are exempted from registration, and this is the criteria used. Number one, if the company's annual turnover is less than Kenya shillings 5 million, and the company has less than 10 employees, they are exempt from registration. Let me repeat. If your annual turnover is less than Kenya shillings 5 million, and you have less than 10 employees, then you are exempted from registration. Please note that the law talks of "and." So these two these two elements must be present, all right, for you to be exempted from registration. Please allow me to move to the next slide before we look at the other obligations and look at certain entities or certain businesses that look at, sorry about that, and look at certain businesses that require mandatory registration. And these are the businesses. If you allow me, number one is gambling entities. Number two, if you are operating an educational institution, a school of some sort. Health administration and provision of patient care. Number three, hospitality industry firms, excluding tour guides. Number four, property management, including the sale of land. Number six, if you are in the financial services industry. The next is telecommunications network or service providers. Doing direct marketing. Transport service firms, including Uber and the rest. And finally, businesses that process genetic data. I would believe these are companies that deal with genetic data, would be health information touching on items like DNA and stuff like that. So that is the first obligation. After registration, then of course we will see that in a later slide where we are talking about even renewal and the charges that are applicable, that are payable to the government for registration. The next obligation is, if you are a data protection, if you are a data controller or processor, you are required to appoint a data protection officer. Now, a data protection officer can act for even more than one companies. It is allowed, but you are required to appoint a data protection officer. This is a statutory position that you are required to have if you are a data controller or a data processor. The next obligation is that you are required to obtain consent from your data subjects. Now, it's upon you to ensure that your data touch points include consent from data subjects. In some other instances, you will be required to conduct a data protection impact assessment. What this means is, if the exercise or activity that you want to undertake, or the nature, scope, context, and purpose of an activity that you wish to undertake poses or exposes your data subjects to data protection risks, then you will be required to do a data protection impact assessment to see what are the risks, what are the data protection risks that are involved. And again, you are able to put in place certain mitigation measures that would address these risks. Please remember that once you conduct this data protection impact assessment impact assessment, you are required to submit your report to the data commissioner within 60 days before carrying out that activity. what are some activities that would require a DPIA? Just as you do an environmental impact assessment when you are doing a heavy construction, in a similar manner, you are required to do DPIA when you are dealing with projects that put your personal data, your data in your custody at risk. You know, some could be, say you are a financial institution and you want to change your core banking system. You know, you want to move from service provider A to service provider B. That would be an item that would require an impact assessment. If you want to transfer personal data from Kenya, say, to another country, you know, or you want to move from locally hosted servers, you want to move to the cloud. You know, those are some elements that would require a data protection impact assessment. So we have already looked at that. Now we are looking at the registration process. Richard, can we hear from one of our members just some few comments on how we are progressing, yeah? To ensure that we are moving together?
Doreen, you can say something to confirm that you have followed something. Doreen, Fatuma, you can say something as well. Fatuma Ibrahim. You can unmute yourself and say something. Somebody courageous, come up and say something, please, so that we do not waste time. Personally, I'm learning a lot of things.
Hi, Richard.
Yes, Karemi.
Okay, I would like to know what are the other functions of a data protection officer?
Okay, all right, that is a good question. Functions of a data protection officer. That one will data protection officer functions. Okay, all right. Next, somebody who will confirm that they are following.
Hi. Hi, Richard.
Yes, Esther. Is it Esther or Faith? All right.
Faith.
Faith, okay.
Yeah, I just wanted to ask if there are limitations as to who is supposed to be a data protection officer.
Okay, limitations, data protection officer. Okay, we'll address that once he is done. Okay, good. I think we are progressing on well. The questions are coming.
Thank you.
Yes.
Thank you, Richard. You know, with virtual sessions, it's very important to confirm whether we are together.
You are right.
Because we could be progressing and somebody is busy making ugali and for supper.
Okay.
Thank you for the confirmation. So then we are looking at registration. Registration is a process. It is a digitized process that requires, there's a standard form that's called DPR1 form. DPR1 form, which entails provision of particular information. So this information, in addition to provision of the same way when you are applying for registration of a company, or you are applying for registration for ID, similar, it's in a similar manner. You know, and most of the information required is similar to what you would have been, a typical government agency would require from you as a registrant. Now, the second point is that you will be required to attach certain documents. The first document is proof or receipt of payment of the registration fees. you will be required to provide your constitutive documents, that is certificate of incorporation, your MEMATs and all that, your constitutive documents. The other document that you need to provide is the contacts, your key contacts, or the person that is your data protection officer. Who is your data protection? Who is the data protection officer for your company? The next requirement is a description of the kind of data that you collect from the public. The next item is the purpose for which this information is collected from the public. Another item that you will need to clearly describe is what are the measures that you have put in place as a company to ensure that the data collected is safeguarded. In other instances, you will be required to provide, and those measures sometimes are contained in your policies and procedures, your privacy statement, your privacy notice, your data protection policy, your data protection procedures, your privacy statement, and all that. These are a set of information that is helpful in enabling the data commissioner to process your application. Then when it comes to fees, please note that this license is renewed every 2 years. Okay, and there are 3 categories. The first category is MSME, or micro and small data controllers / processors. Their description is that they employ 1 to 50 individuals. Annual turnover is around 5 million. So for registration, you'll be required to pay 4,000. For renewal, 2,000 shillings. Then from micro, we move to medium data controllers / processors. They employ between 51 to 99 employees. Their annual turnover is 5 million and 1 to 50 million. For registration, 16,000 shillings, and renewal, 9,000 shillings. Then we have large data controllers and processors. They employ more than 99 employees, and their annual revenue, turnover or revenue, is more than 50 million. Registration is 40,000 and renewal is 25,000. Now, somebody asked about the data protection officer and the functions that are found that a data protection officer is required to do, and also about the qualifications. So now, I'm sure certain professions, which I am not going to mention for the sake of my personal security, would have preferred that this act of parliament stipulates that a data protection officer should be, say, a lawyer. A data protection officer should be an IT professional. A data protection officer should be specific professional. In fact, I am informed that during the public participation and lobbying exercise, certain professions that we wouldn't mention were pushing that there be, that it be defined in the act. However, the drafters of this legislation truly understood that beyond academic qualifications, sometimes your personal interests and even your personal drive and items that you may not have learned in school, then you would become adequately equipped. So what you require for you to be appointed a DPO, number one is academic or professional qualifications, relevant academic or professional qualifications, which may either be learned in school or items that you have learned along the way, all right, in matters relating to data protection. So ideally, we have data protection officers who are lawyers. We have data protection officers who are IT personnel, who are IT professionals. We have data protection officers who are from finance, who are from, but have experience within either training or work experience around governance, risk, and compliance. So, and again, there are professional courses that that somebody can take in order for them to increase their knowledge and even employability around this area. Okay. So, and again, as I mentioned earlier, a group of entities can appoint one DPO, provided that the DPO is accessible and available to support each of the entities within that group of entities. So the function of a data protection officer is similar to that of other statutory positions, such as the MLRO, the Money Laundering Reporting Officer. Number one is advisory. You advise your employer on data protection issues. Number two is to ensure compliance, to ensure that your organization complies with the law and the legal requirements. That is training. You are required to conduct trainings like this, like the training that we are having right now, over your staff members, both executive and top leadership of your organization, and even all the other employees. Number four, you are required to be the subject matter expert. So you provide technical support whenever data protection impact assessment is being conducted. Number five is regulatory relationship management or regulatory compliance or regulatory affairs management. You are the key contact between your employer and the office of the data commissioner. So again, you play some RM role at this level.
I can see the roles resemble the labor officer, almost the roles.
Yes, I fully agree with you, and this is typical of statutory positions. I think they are copy and paste and borrow every time you are dealing with the statutory offices. Statutory roles. They are also similar to Money Laundering Reporting Officer, MLRO, and other statutory offices and roles. All right. The next thing we look at is data breach. And of course, in risk management, there usually are three levels of risk management. The first level of risk management is prevention. And that is the desirable risk management approach. If you can prevent a risk from happening, and in this context, we are talking about a data breach. If you can prevent a data breach from happening, then you are assured that your controls are effective. Now, the second level is, in case you are not able to prevent a risk from happening, then you can mitigate. For example, you can be able to reduce the impact from escalating. All right. Say if there was a data breach and you realize that one customer or one client's data has been breached in one way or another, then you notice that it is escalating. They are now getting to the second client, third client, fourth client. If you are able to mitigate this and prevent it from going to the fourth or fifth client, then you will have mitigated. Or if there is a personal breach and the attackers, the cyber, the people who are conducting this personal breach have not yet, the damage has not escalated, then you will be, you are able to reduce the impact of the data breach. That's the second level. The third level is where the damage is already done. All right? And when the damage is already done, then you ask yourself, how do you restitute, or how do you put your data subjects back to the position where they were before this breach happened? Again, at this level, you also ask yourself, what are the gaps in my processes, in my procedures, in my systems? What are the gaps and what am I supposed to do to prevent this from happening in the future? That's how you manage data breach. But also remember, should a data breach happen, you have two obligations to notify. First obligation is to notify the data subject. Second obligation is to notify the data commissioner of the breach. So I have mentioned this earlier on. I covered this largely by explaining the considerations. What you look for, what you look at before, before determining whether a DPIA is necessary. You look at the nature, scope, context, and purpose of the proposed operations, as I gave examples of items that would require a data protection impact assessment. So, having considered that, and if we are, assuming we are data controllers or assuming we are data controllers or data processors or even data subjects. So what actions or what are the conclusions or what steps do we need to take? Number one, in case we have not formulated and implemented data protection policies and procedures in our institutions, then we are required to formulate and implement these data protection policies and procedures. In the event that we already have these processes within our organizations, the next step would be to conduct compliance reviews or gap analysis. And gap analysis means we subject our policies and procedures to the law and find out, are there any gaps? And if there are any gaps, then we are required now to embark on an implementation plan on how we are going to seal these gaps. The best thing about doing this yourself as an organization is that you are able to evade or avoid a scenario where the data commissioner comes to the ground himself. because they are like, when they find these gaps, then you would be exposed to fines, penalties, or even some regulatory action. So the second action point would be to review all your data points for compliance. For example, do you have forms that clients fill when they are coming to seek for services? Do you have registers? Do you have particular information? How do you handle personal data at all those data points? When you are able to look at this, you are able to ascertain the gaps within your processes, and then you seal these gaps in advance. All right. The third obligation or action point would be, if you haven't appointed a data protection officer, then you should start that process. In case they are not adequately trained, then you should see how they will get trained. The other action point is on registration. I will not belabor that point, only to say that we also provide services pertaining to registration and all that. The other action point is to undertake data protection training. Please remember that these trainings are very important, especially for your frontline officers. You are a hospital. How do your frontline officers handle data issues? You know, very important. And in fact, in your organization, and you are also required to keep records of all the trainings that you have provided. Again, we train institutions on data protection. The other action point is to ensure that the consent that you receive from customers meets the threshold that we discussed earlier on. Again, do you have a breach management process in your organization, and is it known? Is it socialized through to your members of staff? So, all right. I should be done in the next 5 to 7 minutes or so, with your kind permission. So, complaint handling process. How should you? In fact, we are also data subjects. Maybe we have been subjects of data breach. Our data has been disclosed unlawfully. What should we do? Before you get to the office of the data commissioner, the starting point is to lodge a complaint with the data controller or processor who breached your data. That is the starting point. In case you are dissatisfied with how your matter has been handled, then you proceed to the office of the data protection commissioner. How does the office of the data commissioner handle complaints? The starting point is lodging of a complaint, which is done virtually. The second point is that the commissioner will do registration and admission. Of course, not every complaint is admitted. You know, some complaints fail to meet the threshold and they are not admitted. So once a complaint is admitted, then you move to the third step, which is notification of a complaint. This one is issued to the data controller or processor, the company that has abused your data. Then the fourth step is where they respond. The fifth step, the data commissioner considers the complaint and the response and makes a determination. When they make a determination, then they issue an enforcement notice. Now, when an enforcement notice is issued against the data controller or processor, they will be required sometimes they would say put in further comments or further responses or start to negotiate. All right. That's the 7th stage, where now the enforcement notice may be reviewed. Now, once the enforcement notice has been reviewed, the next step is, in case you disagree with the determination of the review under stage 7, then you can appeal to the High Court. Okay? Now, in case you do not appeal or your appeal is unsuccessful, then you move to the 9th stage, which is the regulator will issue a penalty notice. Say you have been penalized certain amount, say 10 million, 5 million, all that. The next step is, in case you don't pay this the penalty, then enforcement follows thereafter. In the usual way, enforcement takes place. Just looking at a few examples of the cases that have been there. Number one is, and this information is public information. It's available this information is in the public domain. The first company is Oppo. Oppo is the very first company to be penalized. They were penalized 5 million shillings. What did Oppo do? The complainant purchased an Oppo phone, and they took a photo. And they took a photo, and they posted it on Instagram. Then Oppo, and then of course, I think it had a watermark, or the lady said this photo was taken by my Oppo phone, through using my Oppo phone or something like that. Then Oppo took the photo and circulated it. So the data subject lodged a complaint. It went all the way. Oppo Kenya was unresponsive, did not show any commitment or any steps towards protecting personal data, and they were penalized 5 million shillings. The other matter which is ongoing, and we may not be able to comment much on it, is about a hospital, which the hospital, it is said that a client visited the hospital and they felt that their personal data was misused, and they lodged a complaint. The best thing about that is that the hospital has shown commitment. It has been able to provide, proof and information on on the steps that it is taking to remediate the process, including procedures and processes for ensuring that this does not happen again. However, one of the areas that the commissioner found fault against that hospital was that they had not undertaken adequate training over its member of staff on data protection. So, as an organization, remember that you have an obligation to provide training, sensitization, and awareness over your staff members. And every time you do this, ensure that there is a register, and that register is everybody signs, and that in case, and you keep the records, you keep the records somewhere of these trainings that you will have conducted. The final case was a constitutional matter where Katiba Institute had gone to the High Court, seeking a clarification on. So in the matter involving Katiba Institute, the question was whether a data subject can go to court before the matter is heard and determined by the Office of the Data Commissioner. So that was the question before court, and that is the area that is important for our training today. So the court held that a data subject must exhaust all other mechanisms, including the Office of the Data Commissioner, before going to court. So, ladies and gentlemen, that being the segment talking of fines and penalties, we close at that point and open the floor for questions or clarifications or comments.
Thank you very much, Anthony. You can clap for Anthony. Thank you very much. Clap for Anthony wherever you are. Appreciate him for that wonderful presentation. Anthony, before I forget, please write your number on the chat. Anthony, please write your number because there are people who could like to get some advice, some clarification, some future. Anthony has put his number on the chat. 0715387308. If you want some consultation, you can reach out to him. His email is anthony.nganga@gmail.com. Thank you very much. All right. She leads. So there, kindly mute she leads. Thank you very much. His contacts have been given there. His name, Anthony Nganga, telephone number 0715387308. Then email is anthony.nganga@gmail.com. Now, let us go to the questions quickly. We have like 10 minutes to do that. My good friend and former colleague Florence is asking whether oil marketing companies belong to the class that is supposed to register. And also, we have a question by somebody who's asking whether social enterprises are also required to register. Then another person was asking, what are the most critical components of a data protection policy? I guess you can answer those questions and then you can move to the rest.
Thank you very much, Richard, for that. I've shared my contacts on the screen, including my email address. So the first question is on whether NGOs or social enterprises are required to register.
Yes.
So the starting point is that registration is not limited or is not determined by whether you are a profit-making venture or not. The primary consideration is the issue of number one, number of employees, number two, turnover. That is the primary test on whether you are required to register. Secondly, you could be an NGO with operations in an area that requires mandatory registration. For example, you are an NGO in the healthcare industry. Okay, so there are other considerations in addition to being an NGO that need to be, evaluated as a whole for us to be able to identify whether your specific organization would be required to register. But going by what the Act says, it talks of turnover and number of employees. And from there, it provides for mandatory registration.
Good. Then somebody is asking, what are the critical components of a good data protection policy?
Thanks. That's a very good question. And for your information, we do formulate and even do gap analysis for policies and procedures. The starting point of a data protection policy is, number one, it must clearly define the type of data that this organization collects. Number two, it must highlight critically the safeguards that this organization has put in place for safeguarding personal data. Number three, it must contain a training clause on how training is done and all that. It must also provide a clause on data retention. How long do you retain data? Number five, it must contain, data collection and consent management. Another key component is breach management process. How do you manage breach? Another key component is who should data subjects get in touch with in your organization in case they require to talk to you on data issues. So those would be the major elements of a consumer protection policy.
Thank you very much, Anton. There is Jane G. She's asking, they have paid, but the payment has not reflected. They used RTGS. What should they do? Who should they contact, given that they have paid and there is no that confirmation that payment has been made? Who should they contact?
Usually, there is when you send money via RTGS, you get a payment advice or a remittance advice, which says this amount of money was sent from this account to this beneficiary account. That's point number one. Point number two, your bank is able to confirm whether that transaction was credited on the other side. Okay? If your bank can provide you with that confirmation showing that this money was credited to the other bank account, that is an item that you can use.
Anthony, I already have that. I have the remittance. I keep going to the website to click to see if they have confirmed payment, and yet that is yet to reflect on their end. Is there someone I can call or share the remittance with so that we get the registration certificate?
Okay. So we can pick the conversation offline.
Okay, so I can call you offline.
Tomorrow.
I can reach out to you. Okay.
Tomorrow.
Okay.
And Anthony is a lie, he will bill you. I'm joking. The other question that has been asked is, where is this question? We have answered that one. Felix Kimonya is asking, what are the expectations from HR department in relation to data protection? In fact, Felix, our next topic is how to conduct a human resource audit analysis. That will really help you. But before we go to the other section, Anthony, you can respond to that. But our next topic, kindly put it somewhere. You will receive notification. It will be how to conduct HR audits, and it's quite related to what we are having today. Anthony, you can respond to that.
Sorry, Richard, you will forgive me. I was looking at another question by Florence a war on whether an annual marketing company is eligible to register under category number 8. Again, before we even go to mandatory registration, the first point is turnover and just a minute, turnover and the number of employees. Now, this company being in marketing, I believe there's a reason why the legislators were very specific about marketing. All right. In my view, if your company does not meet the first test on turnover and the number of employees, then on the issue of marketing, from my slides, we are talking of just a minute. Okay, direct marketing is the concept of that are wholly or mainly indirect. Direct marketing is a bit different because direct marketing is where I have information about, say, Richard. I know Richard fuels, this much somewhere. I have that information. Say I'm a credit card provider, so I have that information about him. So direct marketing is where I target specific clients whom I have, in quotes, insider information or prior information about, such that I am taking advantage of data that has been availed to me from other platforms to directly market to these individuals. So that one would be different, because I don't understand what your oil marketing company means or what exactly you do. So I may not be able to give you a precise answer. But item number 8 refers to direct marketing largely. The people who send you SMSs and tell you a certain club will be open at a certain hour, those companies. That's what direct marketing is.
All right. Thank you, Moses. He's asking whether she can ask a question. The guy, Moses, you can ask a question. The guy, Moses.
So I see the guy's question is, for how long is it considered practical to hold a data subject's personal data after they have left an organization? Should be 7 years. Usually 7 years from the time they leave.
All right. Very good. I don't know which question we have not responded to. Glad is saying that is a very informative presentation. Informative, that is Irene Musevi. Quick question. That one has been responded to. Now, since we have our good friend Anthony Nganga's number and email, I am sure you're going to invite him for trainings. He has asked, there's a question, how does a training, what constitutes a training for data protection? Briefly, what does it contain?
All right. So probably, if you allow me, there is another question from Felix Kimonyi, who is asking, what are the expectations from HR department in relation to data protection? Wonderful. Number one is that, yes, Karimi will give you a chance. Number one is, as HR, you are the custodian. Like when employees are being onboarded, from the induction process and all that, you are the contact department that should set the tone on data protection. That is number one. Number two, in terms of training, you are the custodians of, institution-wide training. And you could include data protection as part of your training, annual, quarterly, or whatever training programs. Number three, the good book says that to those who much has been given, much is expected. The item number three is that as a HR professional, especially because you hold sensitive personal data, you have information about my spouse, about my children, about my mother, all those details you have, and that is sensitive personal. You should be an ambassador of good data protection processes, and one of the most important things that some progressive HR departments are doing is to constantly implement and cultivate a culture of responsible data protection processes within the department and within the organization. I don't know if that answers you, Felix, but as we proceed to respond to Felix, okay, can you hear me?
Yeah, we are getting you very well.
All right, I have seen the next question from Faith on what would constitute a training manual for data protection. Yes, the next that question on what the training manual looks like for employees and data handlers is that primarily we want them to understand. The starting point is to understand the legal and regulatory framework. That's number one. Number two, they need that is item number one, which is an overview of the data protection landscape. Now, item number two, is that you train them about specific obligations under the Data Protection Act. Number three, you train them and socialize your policies, procedures, and the items that the measures that your organization has put in place to ensure appropriate data protection. The other one is that we also want them to know, in case as an employee, I leak a customer's data or I misuse a client's data or even another employee's data, what does that mean to me? What are the repercussions internally, even before we look at what the institutions would be doing for an organization, for the organization or the employer. The next important thing is that to link their roles with particular expectations in terms of data protection. That's what it looks like. It is not a 1 hour or a 2 hours activity. Sometimes it would take more time, or you would have more than one sessions for you to be able to cover these aspects. In detail, in good detail. Another thing that you would consider is to have targeted training sessions. For example, if you are a hospital and the largest, you're able to hear me well?
Yeah.
And the first point
we can't hear you.
Oh, as we can hear
it's
you.
not very clear. What happened to the volume?
Maybe you check on your end, because me, I can hear him.
My end is okay.
Because we can hear him.
Yeah, we can hear.
Anthony has left. I think.
I think he's rejoining.
Ladies and gentlemen, as we wait for Anton to come back, I think the main meat of our discussion has been brought to our attention on very many aspects of data protection. I'm very sure we are going to do something out of what we have learned. And as I've said, our next training, which you will be informed, it is how to conduct human resource audits. Anton, welcome.
Thank you, Richard, and sorry about that slight disruption. I was talking about targeted training sessions where, say, as a hospital or, you know, a player in a certain industry, you would, have specific trainings for specified trainings for specific audience. That is another thing that we need to also, that could be considered as part of the training program. Yes, Richard, I don't think if there is any question that I have not answered. Yes, there's a question by Cliff, whether we do data protection policy at a fee. Yes, we do.
Ladies and gentlemen, anything that is good has to come to an end, and because of time, we will say...
Richard, maybe one more.
Okay.
Vanessa.
All right.
Oh, and then Karimi's hand was up. I think we can give a chance to hear the comments.
Okay. Thanks, Anthony, for the chance. So I wanted to inquire about, I received an email from our medical provider. They wanted me to give a consent of the employee's information, but it has been a back and forth thing where I wasn't so sure on what I'm supposed to do. So maybe you can advise me in regards to the same.
So you are a HR professional?
Yeah.
You received a request from a hospital?
Medical provider, a broker, in fact.
Well, an insurer, an insurance agency.
Yeah.
So they wanted you to give consent so that they could do what with the data?
Yeah.
The data about your employee?
Yeah.
Okay, that's a hot potato, and I hope you didn't give them, because consent with regards to personal data cannot be given by an employer, can only be given by the data subject themselves.
Okay.
So depending on the nature of the request, again, we haven't had the benefit of seeing the request, but depending with the request, in most cases, you need to avoid giving consent for other people's personal data, even if they are your employees, unless if the employees have expressly given you that that consent or that permission, and you would need to also let them know, you know, even when you're if they have given you consent, you need to let them know that this is being requested.
Okay, so in this case, they already have our details, like the name of the staff, they have the ID numbers, they have their telephone numbers, the emails, like they have that data that is required for the registration of medical services.
So what did they need? What did
they wanted me to sign that letter.
Yeah.
Yeah, they'd written a letter, so they wanted me just to sign and like give consent that about the employees' data that they already have.
Okay, that one I would advise you to seek counsel before you.
Anthony, can you hear me?
Yes, I can hear you, Clifford.
Yeah, sorry for interjecting into the conversation with Karimi, but also being mindful of time. Let me just offer a very quick overview, which I think may be helpful to others who might have the same question. But I like how you've answered it, because you've actually given an emphatic answer to say that no one is authorized to issue data on behalf of someone else. typically what would happen, if I may just give an example of a specific institution, you would have Unilever Kenya. They have taken up a medical cover by APA Insurance, and Nairobi Hospital or Aga Khan or Karen Hospital requires information from time to time from APA Insurance on the Unilever Kenya employees. So in this case, it could be a case where APA Insurance has sent an email to Unilever to ask for an approval to share that data in one form or another with either Karen Hospital, Aga Khan, or Nairobi Hospital. But your answer to Karimi, which is, as a HR practitioner in the unit for whichever corporate she is working for, she has no authority to issue out rights of that data without the primary data subject issuing that approval. Thank you.
Thank you, Clifford. In the interest of time, since we have the contact of Anthony, we will say that let us close the discussion and appreciate those people who have been able to attend this particular conversation of data protection. Data protection has become a minefield, and people are using it for doing a lot of things, and there are consequences to it. So it is important for us to acquaint ourselves with the data protection essentials, which we have been given a spark, which means now, even if to organize for a larger conversation, we can easily do something about it. Anthony, thank you very much. The attendance, thank you very much. As I've said, our next discussion or topic will be on how to conduct human resource audits. And I'm seeing that it's quite related to the topic that has just left the floor. Ladies and gentlemen, thank you very much. Unless, Hosea, you have got something, I'll say good night and God bless everyone. This is Richard J. Magoma. You can say goodbye in your language, the language you love most.
Thank you. Good night and God bless.
Thank you so much.
You're welcome.
Thank you. Goodbye.
Thank you very much. Hey, Shilitz, you have not stopped smiling. You have smiled from since we started. You should shower that smile to us. Some of us
Yeah, my name is Julia Chege.
Thank you very much. Thank you very much. God bless everyone. I am sure we have learned something that we can be able to use in our professional undertakings. Doreen, how are you?
I'm fine, thank you. How are you?
Very well, very well. Esther, how are you? Dagaya Moses, I can see you are a counselor as well. If your picture is...
Yes, Richard. Yes, Richard.
Great. We should talk after this. Probably you can have something to tell us as well. You have a topic.
Sure.
Most.
We'll have a session.
Yes. Okay. Yeah.
Thank you
so much.